Welcome. This is part 2 in our series on the anatomy of a trial. So what are we talking about? We've been examining what's the difference between what you see on TV, film, and on the stage when you see a portrayal of a trial scene, and what really happens at a trial. And today we've got a distinguished panel, and I will introduce them in a moment. We will talk about some of the topics. In a previous show, we talked about the jury selection, we talked about the opening statement, and we talked about the examination process. Today's show, we're going to cover the cross-examination. We'll talk about the closing statement, and everyone's popular topic, we're going to talk about jury deliberation. What happens when the jury goes behind that closed door? But first, let me introduce our very distinguished panel. We are privileged to have with us Judge Stuart Schiffman. And Judge served as an associate circuit judge in the 7th Judicial Circuit of Illinois from 1983 until his retirement in January of 2006. His assignments covered all areas of the law, from small claims to class action litigation, with an occasional murder thrown in for spice. Judge Schiffman presided over 175 criminal and civil jury trials, and he's a member of the Illinois Judges Association, American Bar Association, and other distinguished organizations. Prior to his judicial career, Judge Schiffman served as an assistant state's attorney in Sangamon County and as an assistant attorney general for the state of Illinois. After retirement, he joined the Office of the State Appellate Defender, serving for 2 years until leaving the office for private practice. He's the author of numerous articles and served many years on the Illinois Judicial Council. He's also an adjunct faculty member at the University of Illinois, where he's taught courses like evidence, law, and literature, and great trials in American law. Next to Judge is Nancy Martyr, and she's a professor of law at Chicago-Kent College of Law in Chicago, Illinois. She's a graduate of Yale College, Cambridge University, and Yale Law School, where she was an articles editor of the Yale Law School. Professor Martyr has clerked at every level of the United States federal court system, including a 2-year clerkship with Justice John Paul Stevens at the U.S. Supreme Court. Professor Martyr has written numerous articles on the American jury system. Her articles on jury have appeared in law reviews such as Northwestern University, Texas Law Review, and the Southern California Law Review. She also has written a book about the jury called The Jury Process, and organized 2 law review symposia on the jury, including one which is the renowned 50th anniversary of 12 Angry Men. We are so privileged to have her. And next to her is our third distinguished panelist, and that is Marty Dolan. And he's the owner and principal of Dolan Law Offices, PC, in Chicago. And he's been a practicing trial lawyer for 20 years in the area of personal injury, wrongful death, and civil rights litigation. Marty graduated from John Marshall Law School in 1988 and St. Mary's University in 1985. He's tried 49 jury trials to verdict. He holds the second highest verdict in DeKalb County's history for medical negligence cases. He was nominated one of the 40 under 40 attorneys to watch in Chicago, and he was nominated by his peers as a super lawyer for the past 6 years and selected to the leading lawyers network consisting of the top 5% of attorneys in Illinois. And he's appeared before the 7th Circuit Court of Appeals and the Illinois Supreme Court. We are very privileged to have a very distinguished panel that can really help us out in figuring out truth from fiction. But before we go into the topics on our Part 2 show, I'd like for us to ask the panel some general questions about the trial process. And let me start with you, Marty. How does the way trials are portrayed in film and TV affect your preparation for trial? Or does it?
In any case, no matter what, if it's going to go to trial, there's a component of potential jurors having expectations of what a trial's like versus what it's really like. And oftentimes those types of perceptions of jurors come out in the questioning in the jury selection process. And we deal with it at that time and basically put a lid on any preconceived notions as to how jurors view trials. And then secondly, there occasionally might be a comment or two from jurors about their expectations of evidence or how they view the process, and they maybe watch shows that influence the way they may view the trial, like a CSI or something like that. And although that's part of our culture and our media right now, we have to dispel those theories that they have to put aside any issues they see on TV as to how a trial is supposed to go and follow the process as the judge instructs them along the way.
You know, some of us are old enough to remember the Perry Mason show. And Perry Mason was a lawyer who never lost one case, I guess, in his entire career, but that turned out to be a mistake. But he would always solve the crime in the courtroom. He would always prove to the jury, he would be able to point to somebody and say, that's the real killer, it's not my client. And that's always been something that we lawyers in the courtroom have to, talk to jurors about. You may not have this case solved. You're not going to get somebody who stands up in the courtroom and says, oh, I did it, or I'm the person who's responsible. So jurors have to deal with that, the reality, which is much different than the fictional life of a portrayal of a trial.
Well, Judge, is there a film or maybe a TV show that you think comes close to accurately portraying what happens in a courtroom?
I'm a Law and Order fan, but and there are many movies, I think that have been fairly good portrayals. Actually, one of the best movies, again, it's an older movie, but Anatomy of a Murder, which was based on a book and is about a Michigan murder case, is a very, very good portrayal, I think, of an actual trial from beginning to end, including problems that the lawyer has in collecting his fee, which that's for a different show.
Nancy, why do you think these TV shows are so popular, not only in this country, but abroad?
Well, I think people have great interest in the American judicial system. It's a system that garners a great deal of respect. And you're also talking about many countries where you have emerging democracies, and they hear about citizen participation. And America has the citizen participation in the form of the jury.
Let's turn to one of the components. The cross-examination is probably one of the most portrayed parts of a trial. And I'd like, Marty, maybe you can tell us, how often would the main defendant in the case take the stand and be examined and cross-examined? Let's talk about that first, and we'll get more into the cross-examination process.
Well, depending on the type of case, if it's a criminal case, the public has to understand that a defendant does not have to take the stand in their own defense. So if they were ever involved in a trial and the defendant doesn't take the stand or testify, and the trial lawyer or the team of defending that person rests their case, that's perfectly fine and appropriate in that setting. In a civil case, typically the plaintiff, the prosecuting attorney, will call the defendant in their case, and that's perfectly appropriate as well. And I would say I'd be hard-pressed to think of any case where a defendant would not testify either in the presentation, the initial presentation, or their own defense in a case.
How important do you think the cross-examination is to the entire
I mean,
trial
the cross-examination, I think, is overrated to some extent because it is a piece in the puzzle of the presentation of the case. But again, looking at TV and you look, the cross-examination that comes to mind is A Few Good Men, when you have Tom Cruise and Jack Nicholson, and Tom Cruise is demanding the truth and finally gets Jack Nicholson to break down, and that's what everybody I think views as the role model of cross-examination, which is not. However, with that said, I think there is room for trial lawyers in a cross-examination to put on a little theater, a little drama when appropriate, and to make a point. And it's okay to do that, but just not too much. not too much pounding on the table, and they need to know when to stop talking. And that, to trial lawyers, is the most important thing.
Judge, there is a concept known as the 10 Commandments of CrossExamination. Can you tell our audience, what is that?
The 10 Commandments of CrossExamination was something that I learned as a young lawyer from a professor and trial lawyer named Irving Younger, who unfortunately has passed away. And he taught young lawyers how to become effective cross-examiners, because he was very upfront. He said, most lawyers do cross-examination very poorly. And he said, in fact, when there is a lawyer in a courthouse who does a good cross-examination, other lawyers will run to the courtroom to watch him. He said it's the skill that just some people can do and many people cannot. And he had many rules that needed to be followed. As Marty has said, one of the most important rules is sit down. When you've accomplished what you want to accomplish, shut up and sit down and move on to move on to something else. But you should be brief and you should be prepared. And I guess probably the most important thing that many lawyers don't do in a courtroom is listen to what the witness says. Many times lawyers are doing something else and they don't hear an answer that can be very important and very telling in their case.
When preparing to cross-examine, and Marty, I'll throw this back at you, is it always your goal to completely discredit the witness and to make them break down on the stand, as we so often see in film and TV?
No, I mean, it's not my goal, and any good trial lawyer that you would run down to see in the courtroom, I'm sure it's not their goal either. I mean, being a cross-examiner, a good cross-examiner, is like surgical in nature. It's precision and timing and knowing when to get the point across. If the witness is prepared properly by his or her lawyer, you're never going to fully discredit them in front of the jury. In fact, if you make that attempt and that person is an okay person, the jury actually may like that person, it will backfire. So the goal is not to do that. It simply is to corroborate what you're trying to say in your case, get those points across, and as the judge said, sit down.
And once again, this is an area where drama and the portrayal of trials has to be different than real life, because in the portrayal of the dramatization of trials, you need to have that that important moment, that moment when something happens in the courtroom and everybody sees it, so that the audience understands it. But in real life, it doesn't work that way.
Well, when we come back from the break, we're going to talk about the closing statements, arguments, and the jury deliberation process. We're going to see again just what's the difference between what actually we see in the media and what our experts tell us actually happens in real life. So stay with us. I think you're going to enjoy the second part of the show, as I hope you've enjoyed the first. We'll be back shortly.